Good morning, everyone. Welcome to our webinar this morning on navigating biopower regulation in Kenya and South Africa. A particularly warm welcome to our panel this morning. We have Joyce Karanja from our office in Kenya and Xolani Nyali, also from our Bowman's team, as well as Paul Anderson, who's an economist at Genesis Analytics in Johannesburg. It's often said that the purpose of competition law is to protect competition, not competitors or consumers. But this is a principle which is increasingly debated in antitrust circles, and I think is an important context to our debate this morning, which centers on the new biopower restrictions that we're seeing in both Kenya and South Africa. The session this morning was prompted by a recent decision in Kenya, which is the first by the Kenyan tribunal on the abusive biopower provisions there. And of course, in South Africa, we've seen recent amendments to the Competition Act and the passing of regulations which impose new restrictions on the grocery, retail and wholesale sector, as well as agriculture, agro-processing and online commerce. Just a couple of housekeeping matters. Everyone on the webinar this morning is muted and we've disabled the chat function, but you are of course most welcome to send us your questions in the Q&A tab. And as our panelists talk this morning, I'll be sure to keep an eye on those questions for you and put them to the panelists at the appropriate time. We won't be providing any answers in writing, however. If you wish to contact any of us directly after the session, you're of course welcome to do so. And the session will be recorded and will be up on our website for viewing at a later stage. So without further ado, Paul, perhaps you could kick us off and just give us some of the economic context to these new restrictions.
Great, thanks Heather, and morning everyone, and it's great to be just a part of this discussion. I think the idea of biopower is not something that's new. It's not a new kind of concept for economics or in competition law even. It's something that has been around, but I think the way that it's particularly applied in these amendments, certainly within the South African context, does bring a number of important differences. And I just want to highlight three almost defining features of this amendment, which are certainly fascinating from an economic perspective, but also shape exactly how it's going to be applied for businesses. I think the first feature is that this is very much a public interest amendment, and it's not aimed at consumer protection or a normal kind of consumer welfare standard that we're used to. This is very much about the welfare of SMEs and HDP firms in these designated sectors that you've mentioned, Heather. And if you think about that, that's quite unusual, because normally when we think about competition, aspects of the competition law, we are worried about how does it impact prices, how does it impact quality, how does it impact consumer choices. So it's very much a consumer welfare standard. So it's true of mergers, even true of if you think of exclusionary acts, you're worried about how does this impact competition and ultimately consumers. And in that kind of consumer welfare world and standard, concerns of a biopower actually don't feature much. In fact, biopower is normally thought of as a good thing in those kind of assessments. What we have here, though, is something that's quite different. It's targeted particularly at just making sure and protecting SMEs and HDP firms from the imposition of unfair trading terms and prices. So it's very much focused on their welfare, not necessarily kind of consumers' welfare. And I think that's an important aspect to raise and just to note, because it might be something that actually could end up in lower prices for consumers, but still could fall foul of this if it hurts the welfare of these targeted firms. I think the second element which is important just to raise here is that this amendment falls within our dominance category. So for this to apply to a firm, they need to be dominant in terms of kind of a defined purchasing market. But what is quite clear in the guidelines from the Commission and even in the regulations is that the way that the competition authorities in South Africa are looking at dominance is probably going to be a little bit more nuanced than we're used to in the traditional sense. And I think it's quite interesting because elsewhere in the world, often where they've had the same concern about wanting to protect small suppliers, often those kind of the regulations that have been put in place have often been outside of a dominance provision and often even outside of competition law completely. And part of the reason for that is I think there's a recognition that a lot of what might be behind a concern here is almost asymmetric bargaining power between a small supplier and a large buyer, and something that may not be necessarily captured by a traditional dominance approach. And I think our competition authorities are alive to this. And I think it's for this reason why in our guidelines, they make it quite clear and quite explicit that, not only will they be looking at market shares when they're thinking of dominance in this context, but they're also going to be looking at other things such as they talk about supply dependence, alternative avenues for the buyer as well. They're going to be looking at the nature of the negotiations that happened. So effectively, without saying what they're looking at is relative bargaining power between two firms. And that's something quite different from a normal dominance assessment. And then I think the third thing that really matters here and that defines this is that it's about trading practices and terms of agreement, but it's also about prices. So it's not unusual for other jurisdictions around the world to have codes of conduct, rules, even regulations that govern the terms of trade for small suppliers and protect them in that manner. But what is quite unusual is also having a provision that protects against unfair pricing to these players. And I think the reason for that is unfair pricing is a very hard concept to understand what actually unfair pricing means in the context of wanting to look after the welfare of a specific group of customers. So that is quite an unusual element to this. I think to give some comfort here, I think, to give the Commission some credit here, their guidelines and the regulations, again, go to quite a lot of depth to explain how they will look at pricing, unfair pricing. And really what they say is, it boils down to benchmarking. So they'll be looking at whether the prices to these SMEs and HDP firms are lower than prices to your other suppliers. That would be kind of the main, and also whether those prices have changed over time. So they'll be using that benchmark approach. And I do think it's important to note that even where you do have differences, they do allow, those can still be justified, but as long as you have a solid reason, economic reason for that. And I think in a nutshell, those three things, that this is a public interest provision, not about consumer welfare, that this is dominance, but it's dominance in kind of a nuanced way that the Commission is looking to apply it, and that it covers both prices and terms of trade. I think are the three things that really set apart and well, at least define the edges of this amendment.
Thank you, Paul. Joyce, would you like to contextualize the Kenyan provisions a little for us and also talk us through the Carrefour case?
Well, happy to do that, and good morning, everyone. It's a pleasure to be here. Paul, thanks for setting that good background, and I will be touching on comparatively, the differences and commonalities between the Kenyan and South African abuse of biopower provisions. But maybe just starting with the history of the Kenyan abuse of biopower provisions. These were introduced in Kenya in 2016, and they were introduced to address a specific concern around the impact that retailers exert on suppliers. And similar to South Africa, dealing with the unfair trading terms, especially for SMEs who are not in the position to bargain for better terms. Now, the specific concern arose when Nakumatt, which at the time was Kenya's biggest retailer, it had about over 60 outlets across East Africa, and it collapsed. And when it collapsed, it was in a debt crisis, which it's reported that it owed its creditors more than $300 million US. Majority of those creditors were SMEs, many of which never recovered. So in Kenya, it does seem that the abuse of biopower provisions were very much in reaction to a specific event that had happened in the country. When they were introduced, they were introduced as a subsection within the abuse of dominance provisions in the Competition Act. So obviously this suggests that dominance, similar to South Africa, is a precondition for abuse of biopower to even arise. However, in December 2019, the Competition Act was amended, and the abuse of biopower provisions were carved out into their own section, so separated from the abuse of biopower provisions. And in addition, Section 31 of the Act was amended. So Section 31 of the Act specifically gives the authority, the competition authority, powers to investigate restricted trade practices, and abuse of dominance. So previously, there was no mention of abuse of buyer power in that section. So in December 2019, that section was amended to specifically give the authority power to investigate abuse of buyer power. So again, this suggests that the amendments in 2019 were trying to carve out and remove abuse of buyer power from being a subsect of abuse of dominance. So, in terms of where things currently stand, perhaps, and I think Xolani will touch on some of the issues regarding what the standard is for abuse of buyer power. I think currently it appears as if in Kenya, dominance is not a requirement for abuse of buyer power to apply. Moving on then sort of to what is an abuse of buyer power in Kenya. So the Act defines any conduct that amounts to abuse of buyer power in a market in Kenya or in a substantial part of Kenya as an offense under the Act. And if I read the definition, because I think it's important for us to really break down what the definition of buyer power is in the Kenyan context. It's defined as the influence exerted by an undertaking or group of undertakings in the position of purchaser of a product or service to obtain more favorable terms from a supplier or to impose a long-term opportunity cost, including harm or withheld benefit, which if carried out would be significantly disproportionate to any resulting long-term cost to the undertaking or group of undertakings. So breaking this down, it's clear that the buyer must firstly have influence. So as I've mentioned already in the beginning, they were introduced as a subset of dominance. The authority simultaneously with that issued draft buyer power guidelines, which expressly said that dominance is not a prerequisite. And so that is the question, what is the test? Is it enough that a buyer has superior bargaining power? Or, is it market power? What is the test that must apply? And I think that's one of the questions which hopefully we can discuss on this webinar. I think what's clear is that the influence does not need to be undue influence. So just, common commercial bargaining power would arguably fall within that definition. The buyer must also be able to obtain more favorable terms or impose a long-term opportunity cost, harm, or withheld benefit. So in this context, it's clear that the buyer must obtain better terms than those available to other buyers, or better than would be expected under normal competitive conditions. So again, the question arises, what if those practices are common industry-wide practices? Are those captured within this definition? And then the last thing maybe worth pointing out in terms of the definition is that the influence of the buyer must be carried out to result in a significantly disproportionate long-term cost. So I think what this makes clear is that it's one thing to have buyer power and it's another thing to abuse it. And there has to be an action which results in an abuse. So it's not an offense to have buyer power. You have to actually engage in conduct that is abusive. Then the Act gives a non-exhaustive list of what amounts to abuse of buyer power. And this includes delays in payments of suppliers without justifiable reason, in breach of agreed contractual terms, unilateral termination of a commercial relationship without notice or on unreasonably short notice and without an objective justifiable reason, refusal to receive or return goods without justifiable reason, in breach of contractual terms, transferring of costs or risks to the supplier, which would usually be borne by the buyer. And the Act then says that in investigating a complaint, the authority is required to take into account all relevant circumstances, including the nature of the contract, the prices paid to the suppliers, etc. So as Paul mentioned, again, the similarity between Kenya and South Africa there is that in Kenya, the abuse of buyer power provisions are very much concerned with trading terms, very much concerned with pricing, and very much concerned with protecting SMEs. Now, going specifically to the case, the recent case. So let me give a background first, and I'll talk about the background and the facts, and I think Xolani will then analyze it for us. So in the starting of the case is in April 2019, Orchards Limited, which is a food processing company that manufactures and supplies probiotic yogurt, lodged a complaint with the Competition Authority against Carrefour, alleging that it had abused its buyer power. So the background is Orchards and Carrefour had entered into a supply contract in 2016, which was renewed annually, year on year. So orchards complained that during this year, Carrefour had abused its buyer power in a number of ways, including the fact that in early 2019, Carrefour terminated the contract unilaterally in the process of the negotiations, that the contracts required orchards to pay various rebates to Carrefour, that Carrefour had refused to take delivery of certain goods delivered to it at one of its stores, which Carrefour claimed to be defective, that Carrefour returned supplied goods to orchards which were nearing their expiry date, thus transferring a commercial risk to orchards, that Carrefour required orchards to deploy its staff to Carrefour stores, thus transferring a commercial cost to orchards, and that Carrefour had required preferential treatment by requesting free samples from orchards, which it then proceeded to sell. So the authority, on receiving the complaint, it investigated the matter. It gave Carrefour an opportunity to respond. Carrefour requested an extension of time so it could engage with orchards to try and arrive at a settlement. When that failed, Carrefour further engaged with the authority, and ultimately the authority issued a notice of its proposed decision, where it determined that Carrefour had buyer power in relation to orchards and that it had abused that buyer power. So throughout the correspondence between Carrefour and the authority, Carrefour repeatedly asked for evidence from the authority regarding its economic analysis and market assessment of its buyer power, but that was never forthcoming. I think, again, that's something that Xolani will touch on in more detail, so I won't spend too much time on it. So in February 2020, the authority made its final decision. It determined that Carrefour had buyer power and that it had abused it, and then it made certain orders, including requiring that Carrefour amends its supply contracts to delete all offending clauses, all clauses that related to listing fees, rebates, requiring suppliers to post their staff at its stores. And it was given 60 days to make those changes. Carrefour was also ordered to cease and desist from entering into supply agreements that had those offensive terms. Further, Carrefour was asked to remedy the abuse of buyer power in respect of its relationship with orchards by refunding the rebates that had been paid, by paying orchards a loss for the unilateral termination of the supply agreement, and then two very odd orders requiring that Carrefour must seek the authority's approval before it rejects delivery of goods at its stores and before any suppliers deploy their staff to their stores. And then lastly, Carrefour was asked to pay a financial penalty of 124,000 shillings, which was 10% of the gross annual turnover in Kenya from the sale of Orchard's probiotic yogurt. So Carrefour appealed this decision to the Competition Tribunal on certain grounds. So a number of grounds were put forward, including the fact that the authority lacked the mandate to carry out the investigations into the abuse of buyer power. So alluding to my earlier discussion regarding Section 31, did the authority have power to investigate abuse of dominance specifically? It also said that the authority had failed to conduct an adequate economic analysis or market analysis. It also mentioned that the authority had not given Carrefour a fair hearing or a right to really, the principles of natural justice had not been fully complied with because the evidence against it had not been fully provided. And in addition, that the authority does not have the mandate to amend and delete terms of a contract which it's not party to. This is based on the principle of privity of contract. And that the orders from the authority were also unreasonable, particularly the ones relating to, that the authority must approve the rejection of any goods delivered on a case-by-case basis. So the tribunal actually issued its decision, and it was the tribunal's first decision on abuse of buyer power. It issued that on 20th of April. And it upheld some of the authority's orders, specifically the ones requiring amendment to the supply agreement to remove all offending provisions. But interestingly, it reduced the period for this amendment from 60 days to 30 days. And then it also required Carrefour to remedy the effects of the abuse of buyer power against orchards by refunding the rebates and paying the financial penalty of 10%. However, the tribunal overturned the authority's orders regarding the approval of rejecting goods delivered and of approving employees being deployed to its store. And it also overturned the order for Carrefour to pay a damages for loss of unilateral termination of the contract. So the impact of the tribunal's decision is that ultimately it has increased uncertainty for buyers regarding the legality of what would normally be common industry practices, And unfortunately, it has set no clear standard as to what really the standard that the buyers must then meet to be caught by these provisions. So I think the takeaway for all buyers of products and services is that they really need to tread carefully in their interaction with suppliers, particularly with SME suppliers. In terms of the current status, Carrefour has appealed this decision to the High Court, and a stay has been granted. So the good news is that for now, no one needs to do anything as we await the decision of the High Court and whether it will overturn the tribunal's decision. So I'll stop there and perhaps take questions or hand over to Xolani to take us through some of the case analysis. Thanks, Heather.
Thank you, Joyce. We have had a couple of questions, and I encourage everybody in the audience to keep them coming in the Q&A box at the bottom of your screen. Joyce, you mentioned when you were talking about the provisions, this requirement that it somehow relates to a substantial part of Kenya. And someone on the line today is asking, does the case deal with this aspect, or is there any guidance on what that particular requirement means?
So unfortunately not. The tribunal, I think, understood, well, the authority, it appears the authority didn't do any kind of market assessment to establish what market in Kenya, what substantial part of Kenya this arrangement impacted. And I think that's one of the questions that we have is, what was the market definition? And I think it remains the question that it's unclear in this case, and this case has not helped to provide further guidance on how that should be defined.
Great, thanks very much. Xolani, would you like to give us your thoughts on this decision and perhaps assist us to see some potential flaws or angles coming up in the appeal? Have we lost you? Xolani, are you with us? Okay, we may have lost him. Let's move on just to talking about considering the pros and cons of the different approaches in Kenya and South Africa. Paul, you mentioned very briefly in your introduction that sometimes there are very different ways of dealing with this problem in other jurisdictions. Would you like to talk a little bit about that?
Sure. The one, I think some of the areas, it's interesting listening to Joyce, because I think a lot of those areas where, we feel the rub where is exactly, I think, the same areas where, that some of the kind of areas of debate where that Joyce has raised. So I think the one aspect is that I think the concern, having a concern of small suppliers being treated unfairly by big buyers, particularly in certain sectors, particularly often in retail, grocery, and sometimes in online sectors. It's not something that's unusual. It is something that's quite widespread, even in Europe. It's a concern that's been raised. But what you find that is often there in those instances, it's dealt with in a slightly different way, certainly a slightly different way to how we've dealt with it in South Africa. So often it's dealt with outside of a dominance provision. So for example, in countries like Germany, France, Italy, Greece, and I think quite recently Belgium, they do look at this question within their competition framework, but they look under it almost as a heading called economic dependence, which is something similar to dominance and biopower, but it's not necessarily exactly the same. It certainly covers a lot of the elements that our commission is talking about that they're going to look at. It's really trying to understand relative bargaining position. So that's the one way that it can be looked at slightly differently. I think the other way that it's often dealt with is particularly it can be dealt with outside of competition regime completely. So for example, in Europe, with regard to the agricultural sector and the food chain there, particularly for small players, there are a set of rules, a code of conduct, effectively, of guidelines, of regulations, of what is considered to be what they call unfair trading practices. And this, I can hear the similarities listening to Joyce. A lot of those are exactly around payment terms, around certain number of days of cancelling an order of perishable goods, of passing on or transferring certain cost items. So that is one way that it's dealt with. It's interesting to note that as far as I'm aware, never deals with prices in any way, but it is it's quite specific trading terms that they'd be worried about, and they've set up this code of conduct. So that's the other way that it is dealt with.
Thanks, Paul. Xolani, I see you've come back to us. Would you like to give us your thoughts on this Carrefour case in Kenya?
Yeah, thanks, Heather, and apologies, everyone, as technology does what technology does at the worst of times. So I suppose now is the time for a couple of freebies and for anyone on either side of the case to take down some notes. But I suppose the best way that one can assess the case is from the angle of what did the authority and the tribunal not actually decide. Because I think once you understand what the case actually doesn't say, you can then understand perhaps some of the grievances that a Carrefour might have and which may prompt the appeal to the High Court. But what I certainly won't do, and mindful of course that the case is still going to the High Court, is a detailed critique. I think it's probably sufficient for our purposes to look at what was not decided. So my sense is that there were really two main issues that the tribunal was called upon to decide on the case. And that was whether the authority had the power to investigate and prosecute abuse of biopower prior to 31 December, all right? And that really is the focus on the section 31 of the Act, which at the time, I suppose, didn't really refer to abuse of biopower. Secondly, is depending, I mean, whichever way you decide, if the decision is that, yes, the authority had the power at the time to investigate and prosecute abuse of biopower, then the question, I suppose, that follows on is, what was the evidentiary standard? Is it dominance in 2016? Is it market power? Obviously, market power and dominance, you're talking now at a wide industry level. You're not talking about just sort of asymmetric bargaining power relating to a particular supplier, but its ability to impact something at a more industry-wide level. Or was it some other standard that was applicable, for instance, economic dependence, in order to establish biopower and determine that then whether an abuse of such power had occurred. And I think simultaneously then with this last point, the tribunal had to determine if there's a threshold for abuse or whether the very fact of an abuse was sufficient to contravene the law. I mean, what is interesting and perhaps a bit circular is that the tribunal at some point simply remarked, and obviously here I'm paraphrasing, is that if you're able to shift, for example, risk that you should have borne, then you have biopower. And the fact that you, in fact, then did shift it means that you abuse that power. That of course is a bit unhelpful, right? Because you're going around in circles. And so really once you start understanding that at nowhere in the decision did the tribunal in fact engage with or provide any form of assistance to either the authority or parties as to what is the foundation for abuse of biopower. What are the thresholds? What's the standards that you actually need to put forward in order to establish it, and then thereafter establish its abuse? A secondary issue, of course, is that raised by Paul, and that is, are we using a consumer welfare standard or a supplier-centric approach? Again, there's silence on that, but my sense is that if you look at section 24 capital A5, which lists the conduct that amounts to abuse of biopower, it seems to suggest that a supplier-centric approach is preferred rather than a consumer welfare standard, so similar to South Africa. And I think the guidelines published by the authority seem to also point in that direction, because they refer to that detriment to the supplier is what is ultimately assessed. Now, all of these issues, of course, are all relevant considerations and really go to the heart of a predictable and clear regime which guides market participants and their conduct so that they can align their behavior with the requirements of the law. When you don't know what you're going to be assessed with in terms of a standard and what evidence needs to be adduced in order for you to be able to defend yourself, you're unable then to change your conduct to conform with what the law requires. And that really is I believe, quite respectfully, a missed opportunity by the regulators on this aspect. I think, and so the other procedural aspects relating to whether the authority actually undertook an economic assessment, including, of course, the relevant market, whether full discovery was made, whether Carrefour was granted the rights of a litigant, including cross-examining witnesses, and of course, the scope of relief granted by the tribunal, insofar as it applied to all of Carrefour's suppliers, regardless of size and bargaining position, seems somewhat ancillary to the main issues, because all of those flow from whether what was the standard to begin with, and what was the assessment that was needed to be undertaken. All of those really relate to then vindicating rights about relating to that primary assessment that needed to be made, and which, unfortunately, it does seem that the tribunal skirted somewhat. A final point, of course, is whether the authority and tribunal were competent to extend the decision to all suppliers of Carrefour. It does appear that the extension does not align with the findings of the authority itself, because on my reading of what the authority actually found was that the provisions in the particular contract amounted to an abuse. What it did not find is that all such provisions in and of themselves, that their very existence in a contract, are per se unlawful. Because I suppose that then would obviously make the case that an unlawful provision can't be in any contract, and so therefore it can be excised from it. That doesn't seem to be what the authority actually found, and so there's a bit of a disconnect between its findings and the ultimate order, as it were. And so I think those are the main issues that were not decided, and perhaps once you look at it from that perspective as to what is it that was actually not decided by the case, you then ask yourself the question, how could then the orders be what they were? I'll pause there.
Thanks very much, X. So we've had quite a few questions. The first is, I think, an attempt to understand on what basis this decision was applicable to orchards. So in South Africa, we define an SME with reference to turnover and number of employees. As I understand it, that's not a feature of the law in Kenya. But on what basis did the decision decide that orchard was deserving of this kind of protection?
So I'll attempt to answer. I mean, there is no thresholds that are set in the law, but what the definition of an SME is. And because the way the law is drafted, it applies to suppliers generally. So it appears that if you are a supplier and the buyer exerts influence, and again, I think we've made clear that the test of what that influence should be is still in doubt, that test then has been met. The fact that it's a buyer-supplier relationship and these provisions impact you, then that's how orchards then qualified for this protection.
Thanks, Joyce. And then an interesting comment, which I think we could potentially comment on, is would these restrictions in Kenya also apply to buying groups. So you might find that a large number of retailers that are relatively small individually band together, but constitute a very powerful buying group. Could it potentially apply to them?
Yes, and actually the definition of buyer power does talk about buyer undertakings or groups of undertakings. So yes, without a doubt, it would apply to them.
Okay, well, let's move on to a couple of thoughts about the way in which this may interest us in South Africa. X, I'm going to go back to you. Our restrictions only apply to agro-processing, grocery, hotel, retail and wholesale, and of course, e-commerce. And we've also got the dominance requirement, which is written into our legislation. But you alluded to the fact that potentially there is room for a kind of a broader assessment of what dominance might be, specifically in the light of the CAC's decision in the Babalegi excessive pricing complaint. Would you like to comment on that?
Certainly, thanks, Heather. I mean, I suppose, so South Africa, obviously, and the Commission accepts that abuse of biopower is squarely within the abuse of dominance provisions. In Kenya, the position is somewhat unclear since the 2019 amendments, right? Because 2016, they were squarely within, and I think there was no debate that they were within the abuse of dominance provisions. 2019 happens, and we're a bit unclear as to, because they're still broadly within, in terms of where they are architecturally in the Act, they're still within the broader sort of abuse, but there's an attempt really to carve it out, but doesn't say what the standard is. But what is interesting, though, is that though the authority in Kenya has always maintained, even prior to the 2019 amendments, that dominance was not a requirement to prove abuse of biopower. But if you look at the abuse of biopower guidelines, they really replete with references to either monopsony power or some form of bargaining power, right? So I think that there is a recognition by the authority that some form of power is required, but it doesn't really then set what that standard is. And I think in the draft ones that are now, because they're up for update, I think a lot of clarity would help in that regard. So then I suppose the question is whether the power has to be long lasting or whether it can be sort of transitory or temporal, as what Babalegi in South Africa decided. So I think while Babalegi was interesting, and regulators, including the CMA in the UK, had shown an interest in that case, it is not without controversy. And I think the words of the former chief economist of the Commission are really useful, that all firms have some form of bargaining power in the short term, right? But I suppose the question is, how short is short term? And then, my sense is that abuse of biopower, at least in Kenya, contemplates something more long lasting. And also simply because contract negotiations don't typically happen spontaneously, as in the case perhaps with a buying decision from a consumer perspective, which in that case, you could really get a transitory or temporal power that really exists in a very, very short term. But abuse of biopower in and of itself contemplates, I think, something a lot more fixed and long-term and predictable going forward. And so I think there's less of a cross-pollination from the Babalegi principles to abuse of biopower.
Yeah, except I suppose that perhaps at least in South Africa, we now have the notion that a dominant position can come into being even on a relatively temporary basis. And although I suppose Babalegi must be read in the context of the pandemic, it could potentially suggest that any kind of special event in a market which suddenly changes the dynamic could render firms dominant when they may never have traditionally understood themselves to be so. That's my concern, is that it will open the door for more of these complaints based on some sort of market shock. Paul, I don't know if you've got any thoughts on that.
Yeah, I think, maybe less around Baluleke in particular, but certainly I think, Baluleke took quite a different and kind of nuanced view of dominance. And, I think it's saying it might have been particularly within that context, of the pandemic. But I think what is very clear from the guidelines and the regulations on this Biopower amendment is certainly what's in the mind of the competition authorities in South Africa is to take a less traditional approach, I think, to dominance in terms of this Biopower amendment. And by that, what I mean is, if you think of what the definition of dominance is currently, as you're above 45% of a market, you're dominant. If you're in between 35 and 45%, you're assumed to be dominant unless you can show you don't have market power. Whereas if you're less than 35%, you're assumed not to be dominant unless it can be shown that you have market power effectively. And I think really what the guidelines and the regulations in terms of this Biopower seem to be suggesting is, look, they're going to obviously look at market shares, as required by Section 7 of our Act and those kind of thresholds. But it does very much seem to me that the other things that they're quite careful to specify, the things around, they're going to look at supplier dependence, they're going to look around alternatives for the buyer, they're going to look around the context and the nature of the negotiations that happened, seem to me to be suggesting even a more nuanced view, whereas normally we used to kind of hanging dominance on market shares. I think here it's going to be very much an individual relationship, supplier-buyer relationship, and really kind of trying to gauge almost the weight of negotiation power in that very specific relationship. And that's quite a different world to what we used to in terms of dominance. And I think certainly that's what they have in their mind. Whether I think they're successful in being able to use our dominance criteria in that way, both analytically and I guess legally, I think is something that we're going to have to wait and see how that turns out. But that it seems to me that that's how they're wanting to use it, how they're wanting to use that provision. I don't know if that makes sense, or if there's any comments on that.
Thanks, Paul. And then Joyce, we've had a couple of people just asking to what extent you think it's going to be possible for the Kenyan authority to enforce its decision. And perhaps you could comment a little bit on what those enforcement mechanisms are.
So I suppose the question of enforcement, now that it's on appeal with the High Court, we'd have to wait for that decision to be made, and then it would be enforced in the ordinary course. As it's a High Court decision, it would have to be enforced, and it would take the enforcement out of the hands of the authority per se. And I just wanted to comment on something that Paul had said. I think specifically to the Carrefour case, the authority ordered, one of the orders was for the authority for Carrefour to amend all its supplier agreements. And the question then comes up is it not necessary then to determine between Carrefour and each supplier if Carrefour does indeed have Biopower? Because surely it has to be on a case-by-case basis. It can't be, the assumption was made that it's a blanket sort of, Carrefour has Biopower in respect of all its suppliers, and I understand it has quite a significant number of suppliers. So I think that's just another question that, again, the tribunal perhaps should have addressed, which it didn't.
Thanks, Joyce. Okay, so I think it might be worthwhile going on to just offer a little bit of advice to firms that are concerned about falling foul of these provisions. Joyce, can you just clarify, in Kenya, is there an avoidance provision which prohibits you from ceasing dealing with smaller firms, or from deciding never to deal with them in future to avoid this kind of problem?
No, so Heather, there isn't an anti-avoidance provision in the Abusive Biopower provision. So I suppose one of the unintended consequences of this decision could be that buyers could choose not to contract or to purchase goods or services from SMEs that expose them to this potential abuse of Biopower. And I think, imagining what the impact would be to SMEs, I think it can't have been the objective of the Act. I don't think it was the objective of the Abusive Biopower provisions. So it will be interesting to see how that plays out in the market.
X, what advice would you offer clients in Kenya and South Africa?
Well, I suppose South Africa is an easier one because it is limited to particular sectors and also very clearly within a dominance framework. There, it's that you just simply can't anymore be agnostic about the identity of your suppliers as a buyer. You've got to understand whether they might be SMEs or HDP owned or controlled firms, right, as a starting point. And thereafter, you've got to be very clear and careful about any conduct that could be construed as falling within any one of the factors that might constitute abuse of buyer power. And so you've got those justifications have got to be upfront and they've got to be compelling ones insofar as they relate to that particular class. Kenya is a bit more nebulous because we don't know what the standard is. Is it within an abuse framework? Is there some other form of economic dependence, as it were? And I suppose that is really the nub of the issue here. It's that there could be potentially a deluge of, it's the floodgates to nowhere really have been opened by this decision, and hopefully it will be given a bit more structure on appeal. And I don't, because it couldn't have been the intention really that a complete 180-degree turn is made in favor of suppliers at the expense of buyers. But I think that's an unintended consequence of how the decision was prepared, but not that it was the intention. But that is what unfortunately we have at the moment. So Kenya is a bit more of a difficult one. You really have to be extremely careful as a buyer that your conduct, as it were, whether you are dominant or not at this stage, whether it could intuitively fall within one of these listed grounds that constitute abuse of buyer power. And so it really now comes to gut feel, right? And whether you think this is a fair sort of contractual provision. So in short, be very nice to your suppliers.
Thanks, X. I mean, it's quite interesting to me in South Africa, for example, that the sectors of the economy that have been targeted are primarily private sector buyers, whereas you would have thought that at least in some parts of the economy, like construction, for example, state entities might be significant buyers, and they might be guilty of practices like late payment, for example, or habitually shifting risk onto smaller suppliers, which would fall within the scope of these kinds of practices. So it seems to me that it will be interesting to see whether the minister designates other sectors of the South African economy as we go along, and potentially that will be driven by complaints to the Commission about this kind of conduct, even though it falls outside of the designated sectors. And I think it would be interesting to see whether, for example, healthcare gets added, or as I said, other sectors in which state buyers are more prevalent. Paul, what's your advice, at least in South Africa?
I think a lot of what X says makes perfect sense to me. So, I mean, what I would, because we have, at least in South Africa, I think what the regulations and the guidelines to some extent do, I think they do an honest job of trying to identify exactly, how this is going to be applied. I think we do have a bit of a sense. It's not perfect yet, but I think we've got a bit of a sense of kind of where they're going to be looking. So my suggestion would be, if you are in those designated sectors and you are a reasonably big buyer, firstly, kind of know your customers, which ones fall into the categories of SME and HDP customers, so that you know who they are. And then I think for those customers, you just got to think about their prices and their terms. And you've got to think of maybe two different. So in terms of prices, I think what you've got to have a look at is, are they getting a lower price for a kind of a similar product compared to some of your larger suppliers? Or has your price to those smaller players gone down? Now, it's not to say that you can't have lower prices to them. I think the regulations are clear that you can, but where that is the case, you've got to have quite a very clear and defendable rationale for why they lower, and the quantum by how much they lower as well. And I think the guidelines give quite a good sense of the type of rationales that they think would be acceptable in terms of those differences in prices. And then in terms of the trading conditions, I think there you got to look at two things. One is a comparison. Again, do your small guys, are they getting any worse trading terms than any of your larger suppliers, in terms of days to payment days and so on? I think that's the one thing to look at. And again, do you have a reason for any worse terms? But then I think the second thing to look at is really to have a look at whether any of those trading terms to them, how they compare against the list that the Commission has in the guidelines as to trading terms that they think are problematic on their own. They kind of give benchmarks for number of days of certain things around cancelling perishable orders within certain number of days. There's some there which they clearly think are problematic in of themselves without a comparison. So I would suggest kind of those types of analysis you could do to kind of get a sense of whether there could be any risk in that space.
Thanks, Paul. Joyce, there's been a couple of questions from delegates who are attending from Kenya about where this leaves freedom of contract. So are we dealing here with a significant intrusion into a common law principle that's long been held dear? And is there anything to be done about that, is the question.
I think there's an argument that's put forward that one of the exceptions to freedom of contract is where a legislation provides requirements for that contract. So outside of this example, I think the Employment Act is a good one. So for example, where it says, the requirement for annual maternity leave is, X number of days, and therefore your contract is, your ability to negotiate out of that is limited by legislation. So I think an argument could be made that this is one of the legislative carve-outs that the common law principle of freedom of contract accepts. But I think there is still some doubt in terms of privity of contract, and if the authority is not party to that negotiation, how can they then require you to unilaterally amend the contract? So I think it's not clear-cut, but I think an argument could be made that it is one of the qualifiers or carve-outs for the common law principle.
And as X pointed out, this seems to be a decision which is potentially impacting on other parties to other contracts, which seems far more extensive than what may have been anticipated.
That's right, yeah, that's right.
And I think the same might hold true in South Africa too, because we've had a follow-up question about South Africa. Under the Constitution, of course, you have a right to freedom of trade, but that can certainly be limited in terms of the usual justification clause in the Constitution, and competition law functions under the auspices of that. So it does limit your right to freedom of trade, but in a way that's justifiable in line with the objectives of the Constitution. And of course, bearing in mind in South Africa, the very strong public interest focus that's given effect to in the aims of the legislation. Okay, so I think we can wrap up on that point. I'm going to turn over to our panelists just for one final comment or message to wrap up. Paul, anything you'd like to add?
Maybe just a last comment from me is, I think, what has kind of come up through a lot of the discussions from the panel and even from the questions is almost this tension between consumer welfare protection. Do we care about lower prices only, should we? And this idea of what about protecting, certain categories of customers, of these small customers. And I think sometimes it can feel like a bit of a tension there between these two things, particularly when we're talking about, are prices too low to certain groups of customers. I think maybe just to point out there that I think this tension is not something that's by mistake, certainly in South Africa, that it's actually very deliberate, that it's deliberately designed not to be a consumer welfare standard, that it's designed to be something particularly to look at public interest and particularly to look at SMEs, and certainly kind of I appreciate that at least it's been explicitly defined as that. Now, and I think kind of just as we do in mergers in South Africa, where we've got a public interest provision and a competition assessment, I think this falls very much into that same category where it's a different question to a normal competition assessment. And I think it's something that we're going to need to learn as, I guess, practitioners and as companies to kind of manage as we go along, balancing public interest considerations as well as kind of our standard kind of competition concerns that we have. But thanks very much from my side. I thoroughly enjoyed the chat.
Thank you, Paul. Joyce, any final thoughts?
Yeah, thanks, Heather. Perhaps just to reiterate that as things stand, I think buyers generally just need to be very careful in their interactions with suppliers because of the risk of being viewed as abusing your buyer power to the extent that you have it. And I guess just to point out the glaring gap in our legislation, because it's clear this is driven to protect suppliers in the SME form, but there's no definition of what that SME is. So I think that's something that, again, would be helpful for the legislation to provide in terms of giving further clarity. Because like Xolani mentioned, it's important for legal clarity for parties to be able to comply. But thanks very much.
Thanks very much. And Xolani, the last word goes to you since we lost you for a little bit in the middle.
No, I'm still here. I think, listen, the abuse of power provisions, we should really acknowledge the complexities that the authority and the tribunal had to deal with. There are diverging approaches internationally. But that said, I think what in Kenya, what would be helpful is if the relevant stakeholders took a position as to what is the actual framework within which, for that particular jurisdiction, they will approach it, right? South Africa has taken a particular approach, other countries have taken a different approach, but we need to actually know what is the approach in Kenya, what's the framework, what's the standard that needs to be met. And because by its very nature, of course, abuse of power is very uncomfortable, right? Between freedom of contract on the one hand and regulatory intervention relating to protecting a class of suppliers. What's that class? What do you need to demonstrate in order for an abuse to happen? And ultimately, do you even look at consumer welfare, or is it, we think is the case, that you are simply looking at the benefit of a particular supplier? I think all of those things are what we actually need to get to. But before we get there, unfortunately for now, is really what Joyce was saying, i.e. we just need to be very careful.
Thanks very much. Well, it seems that this appeal is going to be hotly contested and really map out the future of enforcement in Kenya, but possibly also in South Africa. I'd like to say a very big thank you to all of our panelists today. Your insights are much appreciated. And to all of the delegates that joined us today, it's really wonderful to see plenty of questions. I hope that we've managed to give you some satisfactory answers, such as they are. And we'll keep a close eye on these developments and perhaps do a follow-up when the appeal decision is forthcoming. Thanks, and have a very good day further. Bye, everybody.
Bye, everyone.
Bye, everyone.
Thanks.